Hello everyone, welcome to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. Jones Act and Maritime Law. Nearby is Galveston, which is home to many popular cruise ship channels. When crew members become injured on the vessels, they may only have access to basic first aid. As a result, by the time these victims obtain proper medical treatment, their injuries may have progressed into something more serious. For this reason, commercial fishing has consistently ranked as one of the most dangerous occupations in America. As an employee in one of the nation's most dangerous industry, you deserve protection from avoidable harm. In the event of an injury, you need proper compensation to help you recover and move on with your life. In the event of a work accident, employers are typically eligible for compensation under the state workers' compensation program. Although Texas legal jurisdiction ends at the shoreline, injury offshore workers are eligible for no-fault compensation under the Jones Act. The Jones Act is a federal law that allows offshore employees to recover damage from employers for on-the-job injury. What this means is that if an employer has been negligent by exposing employees to unsafe work conditions, they may be entitled to compensation. Have you been injured in an offshore oil rig explosion, offshore oil rig accident, or ship accident? In that case, you need a lawyer that understands the very complex and specific rules of maritime law. It will also help if you had a law firm that is committed to fighting the big companies that run the oil and gas industry in the Gulf. Our experienced Jones Act attorneys have built a reputation for successfully navigating complex offshore injury claims. Founding partner John Eddie Williams' father and grandfather both were union longshoremen. Thus, we are very familiar with the dangerous working conditions of that offshore workers face. Our lifelong dedication to protecting the rights of offshore workers has consistently earned us a top-tier recognition as one of the best Jones Act law firms in the country. According to the Jones Act, sailors are all workers who meet the following criteria. First, the injured employee must spend at least 30% of their time aboard the vessel. They also must contribute meaningfully to the voyage operation in any capacity. Second, the injured employee must be under a single professional relationship with the vessel while they are working aboard. This means the employee cannot be a freelancer or independent contractor. Third, the vessels must be in navigation at the time of the injury, meaning it cannot be in the dock and in use of land-based utilities. Navigable waters include both ocean and inland waterways. So, if the ship was under construction, even if it was in the water, it was not navigable at the time. However, suppose the vessel was being repaired. In that case, even though it is not seaworthy at the time of the injury, the Jones Act still applies. Fortunately, normal workers' compensation is still available for those who do not meet these criteria. Jones Act protection covers workers in various industries, not just fishing or oil and gas. Stewards, cooks, barbers, medical personnel, bartenders, housekeeping staff, electronic operators, and mechanics are all vital personnel in the vessel's operation. With this in mind, they are entitled to fair compensation under maritime law if injured while aboard the vessel. Workplace injuries normally occur as either sudden trauma injuries or occupational disease that develop over time. Jones Act claims do not require proof of malice, fault, or even negligence. Moreover, the accident need not have to been Moreover, the accident need not have been exclusively a workplace accident. For example, if a sailor slips and falls on the wet spot at the same time the deck halves violently, either of these things could have caused the fall. Regardless of the specific cause, the Jones Act still applies in this case. Falls are the most common types of Jones Act trauma injuries. These are not just man overboard falls, a slip and fall could occur almost anywhere on board. This is primarily so if the victim is not used to dealing with things like pitching decks and narrow corridors. Respiratory problems are among the most common occupational disease. Breathing mostly filtered air for days or weeks on end is very hard on the lungs. This becomes more of an issue if the victim has a pre-existing condition, or there may be an issue with the filtration system resulting in respiratory issues. Frequently, occupational disease symptoms are not apparent until long after the victim's suffering days are over. However, if the occupational disease originates on the vessel, even if subsequent events contribute to the disease, the Jones Act still applies. Hearing loss is a good example. Working too close to a noisy engine room without proper air protection exposes the victim to hearing loss. Or suppose other on-work related noises contribute to the hearing problems. In that case, the victim is still eligible for Jones Act compensation. When the unexpected happens, the challenges that follow can be overwhelming. A work injury can turn an offshore employee's life upside down in an instant. They are often left to deal with traumatic injuries, mounting medical bills, and an inability to work and support their family. Offshore injury victims deserve compensation for their pain and suffering. Such compensation is available under Jones Act for eligible offshore workers. However, getting a fair settlement may be very difficult without help from a trustworthy attorney. Aggressive insurance reps will try to corner you into settling for less than you deserve. In doing so, they are allowing the responsible party to pay as little as possible. By hiring an attorney who is well versed in maritime law, victims have more control over their recovery outcome. They are more likely to secure maximum compensation. A maritime attorney or maritime lawyer represent individuals, companies, or other entities in connection with maritime law. These attorneys also handle all matters related to maritime law, including marine commerce, transportation and shipping, offshore drilling, maritime accident, and maritime labor, and among others. A maritime attorney may specialize in matters that fall under admiralty law. This law is the set of federal regulation. This law is the set of federal regulation and state statutes related to the safety of ships, their crews and passengers, and the marine environment. Maritime law are a set of codified rules that are enforced on the open oceans. A maritime lawyer is the person who is qualified to represent clients in the courts of maritime law. It is crucial to hire a maritime lawyer if your business deals with ship or shipping. They can help you resolve legal disputes that you may have with other ships, with the government, or with other parties. Okay, everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.